Is 2% a critical mass, Ms. Mahoney?
I don't think so, Your Honor.
4%?
No, Your Honor.
You have to pick some number, don't you?
Well, actually, what
like 8 is 8%?
Your Honor,
now, does it stop being a quota because it's somewhere between 8 and 12, but it is a quota if it's 10? I don't understand that reasoning. Once
Your
you
Honor,
use the term critical mass, and you're into quota land.
Your Honor, what a quota is under this Court's cases is a fixed number. And there is no fixed number here. The testimony was that it depends on the characteristics of the applicant pool.
As long as you say between 8 and 12, you're okay. Is that it? If you said 10, it's bad, but between 8 and 12 is okay because it's not a fixed number.
No.
Would you think the Constitution?
No, Your Honor. If it were a fixed range that said that it will be a minimum of 8%, come hell or high water, no matter what the qualifications of these applicants look like, no matter what it is that the majority applicants could contribute to the benefits of diversity, then certainly that would be a quota. But that is not what occurred here. And in fact, the testimony was undisputed that this was not intended to be a fixed goal.
Ms. Mahoney, may I shift focus away from this to another point before you're finished that I am concerned about? In all programs which this Court has upheld in the area of, if you want to label it affirmative action, there's been a fixed time period within which it would operate. You could see at the end an end to it. There is none in this. Is there? How do we deal with that aspect?
What the policy says, of course, is that it will only take race into account as long as it is necessary in order to achieve the educational objectives. I don't think that this Court should conclude that this is permanent because there are two things that can happen that will make this come to an end. The first is that the number of high-achieving minorities will continue to grow, and that law school will be able to enroll a sufficient number to have a critical mass or meaningful numbers, a substantial presence, without having to take race into account. The second thing that can happen, Your Honor, is that we could reach a point in our society where the experience of being a minority did not make such a fundamental difference in their lives, where race didn't matter so much that it's truly salient to the law school's educational mission. While that, I can't say when that will happen, we certainly know that as a nation we have made tremendous progress in overcoming intolerance, and we certainly should expect that that'll occur with respect to minorities.
We approved any other affirmative action program with such a vague, distant termination date?
Well, in Bakke itself, Your Honor, in Bakke itself, there were 5 votes to allow the University of California, Davis to use a plan modeled on the Harvard plan. It's been in effect for about 25 years. It has reaped extraordinary benefits for this country's educational system.